right now on the Daily Debrief.
She delivered a stillbirth infant in the bathroom, in the toilet.
Experts back up a defendant's claim that her child was born dead, that she didn't kill it.
I think we would have been in shock, and we probably would have been angry.
Her father says she kept it a secret, but what about the deleted text messages authorities recovered? Plus,
she goes to the darkest, most desolate place in this county.
that's where prosecutors say this man and his wife lured his girlfriend to make her disappear. The defense says
there simply is no motive because nothing happens.
The Daily Debrief recaps the day in court. It's Tuesday, September 10th. Good evening, everybody. The defense has the case of an Ohio teen accused of murdering her newborn baby 2 days after her high school prom. Prosecutors say Skylar Richardson learned she was pregnant at the doctor's office, made no follow-up appointments, and did nothing to prepare for the baby's arrival. Richardson says the baby was stillborn and that she secretly buried its remains without telling people because she feared backlash. The state says she killed her child after giving birth alone at home and questioned her father whether he would have helped care for the child had he known.
You would have been shocked, is that fair to say?
Yes.
And you would have been a little angry.
Yes.
But you would have dealt with it, right?
Correct.
You would have made sure that the appropriate steps were taken to make sure that you guys were all prepared, that you had the necessary supplies in the house. Is that fair to say?
Yes.
That baby wouldn't have wanted for anything. You would have made sure that all of that was provided for had she come and told you, in fact, that she was pregnant. Is that fair to say?
Yes.
That was just some of the state's cross-examination of the defendant's own father. We will get to more of that in a moment, but first, this is now a case involving only 4 charges. The top charge is still aggravated murder, the bottom charge is still abuse of a corpse, but the judge threw out the 4th charge, tampering with evidence, after the state's case in chief. Here, the judge agreed that the state failed to present enough evidence to even present that count to the jury. Here is the defense's argument.
As the court is aware, for counts 1, 2, and 3, the predicate for that would be a live birth. The defense's argument would be that not even with the standard of Rule 29, the state has not met that standard and even admitted that they cannot prove a live birth. For count 1, aggravated murder, the state has not established that Skylar Richardson did purposefully cause the death of another under the age of 13. As the court is aware that to prove that someone acted purposefully, the person must have the specific intent to cause a certain result, that is a specific intent crime, and in this case, to cause the certain results of death of Annabelle. They have not shown that, Your Honor, even in light of the standard for Rule 29, and ask that that be dismissed. For count 4, tampering with evidence, that Skylar Richardson, knowing that an official proceeding or investigation is in progress or is about to be or likely to be instituted, did alter, destroy, or conceal, remain, remove any record, document, or thing of purpose to impair an investigation. There's been no evidence on the record that during the dates of May 6th through July 14th, as indicted, that Ms. Richardson did any of that there was any knowledge of an ongoing official proceeding, one that was likely to begin on that date. Ask that that be dismissed as well. And on count 5, abuse of the corpse, I've not heard any testimony on reasonable community sensibilities being outraged. Your Honor, ask that that be dismissed as well.
These arguments are really important as to how the case rolls out. The judge agreed to keep counts 1, 2, 3, and 5, as we said, but asked the state to argue about count 4, tampering with evidence.
First, the state has to prove that the defendant knew an official proceeding or investigation was in process or about to be or likely to be instituted. 2, that the defendant altered, destroyed, concealed, or removed a record, document, or thing. And 3, that the defendant did so with purpose to impair its value or availability as evidence in such investigation. Knowledge of a likely investigation may be inferred when the defendant commits a crime that is likely to be reported. Here, the crime was not a possessory offense, it was homicide. Homicides are highly likely to be discovered and investigated. Certainly, a jury may reasonably believe that a murderer knows this. This is a homicide case. and an investigation was likely into the defendant's crime. People knew that she was in the 3rd trimester of her pregnancy. They knew that she was going to be delivering a baby in a matter of weeks. So when the defendant is suddenly not pregnant and has no baby, people are going to notice. They're going to start asking questions, and it's going to be investigated.
Okay, former prosecutor Julie Rendelman, criminal defense attorney Linda Canty-Bodden, you're with us tonight. You've heard the arguments from the defense and the state. Now I want you to listen to the judge's ruling on this motion to dismiss and tell me what you think.
The facts in this case are a far cry from shooting 2 people and leaving them dead in a neighborhood. I mean, that was the thrust of the Martin decision, as I understand it, that, I mean, in Martin, those bodies were going to be discovered, right? I mean, factually.
And the same goes for this case. People knew about her pregnancy. When she shows up and she's not pregnant and there is no baby, similar to Martin, people are going to notice. They're going to start asking questions, and it's going to be investigated. The fact that there was no birth certificate in this case, the defendant herself prevented that from happening. She had this baby in secret. She did not go to the hospital. She did not tell anybody. And she then destroyed all evidence of her crime. That's tampering with evidence.
The law in the state of Ohio is that constructive knowledge of an impending investigation is not imputed based solely on the commission of an offense. And I think that Straley and Berry and Martin are all consistent in that fact. There is insufficient evidence as a matter of law to sustain a conviction. No reasonable jury could conclude from this set of facts that all the essential elements of the crime of tampering with evidence have been established, so count 4 will be dismissed.
Okay, right off the bat there, let's bring the panel into this. Linda Canty-Bodden, the judge pretty much said, hey, look, prosecution, you're stretching, trying to make this charge fit the facts of this case.
That's right, because they're assuming that indeed she murdered the child, therefore it was always tampering with evidence. But if indeed she did not murder this child, the child was stillborn, then you can't imply or assume that she had the evidence that there would be an investigation.
Julie Rendelman, what do you think?
But then that's part of the charge. The jury is for the jury to make a determination as to A, whether or not she killed that child, and if she did in fact kill the child, whether she acted to hide the remains of the child or to hide evidence to prevent people from having an ability to investigate fully this case. So I'm having a little trouble with this.
Well, Julie, look, he said the legal standard in Ohio is that the defendant needed to reasonably be able to infer that an investigation would be forthcoming, and they have to prove that she knew the cops are coming for me, and that's why I'm hiding this.
Well, I guess my position again is that when you were pregnant with the child and suddenly you're not, and you've gone to a doctor 2 days, 2 weeks before, and they knew you're pregnant, suddenly now the baby's buried in the back of your yard, someone's going to investigate. I understand she's not an adult, but even an 18-year-old may have the sense to guess that they're coming her way.
You're taking the state's side of this, but the bottom line is that side lost. It's okay, Julie. We'll still have you back for another day here. Look, I also want both of your thoughts on this next piece of evidence. Before the state rested its case, it presented a mysterious deleted message from mother to defendant. We've cleaned up the grammar, the typos, the text message abbreviations, but it basically says, he brought you into this world. He is a very good doctor. If you want, you can go to Planned Parenthood, but you have to pay out of pocket, and the doctors are not quality. My doctor is a surgeon and has been doing this for years. I am sick about it too, but I have to do what is best for your future so you will have one. That text was 1 day before Skylar Richardson went to the gynecologist, 1 day before Skylar Richardson said she officially learned she was pregnant. The prosecution did not offer much context in the moment, but one possible conclusion, in my opinion, from that recovered message was that the defendant's mother knew she was pregnant and was counseling her to abort the baby. But during the appointment the next day, the defendant found out she was too far along to have an abortion. The state may need to connect more dots if it hopes to convict using that key piece of evidence. So, Linda, Julie, Am I making a completely preposterous assumption based on that?
Well, the jurors are going to make that assumption, but the defense is going to point out, look, where's the message before it? Where's the message after it? Where's the message from the deleted messages from the mother's phones? Where's the actual messages from the mother's phones? And by the way, even if you were thinking about having an abortion, you find out you have a baby, that doesn't mean you then killed the baby. That's a big leap.
Okay, Julie, look, the defense's own expert got up on the stand today and basically said that she went to the appointment the day after that message and learned she was pregnant and said, don't tell my mom, she's out in the waiting room. And then later the mom acts all surprised to receive the later message that there's a child coming. The surprise apparently was that the child was still there.
Well, that's why everyone, keeps talking about this child. I say child, 18-year-old, 17-year-old acting alone. I think the mother had much more to do with what occurred after this baby was born than simply this child being by herself. And that's my opinion.
We better give her her Miranda rights, Julie.
I think so.
I mean, we're making inferences here, Linda, but the bottom line is that I thought that was a key piece, that, okay, this indicates that this defendant pretty much felt some pressure that she had to get rid of the child. That's assuming it was born alive.
Well, she felt a lot of pressure. She shouldn't be pregnant. She's 18. She's going to school. She was a cheerleader. But the problem is that she also had all the indicia of having a problematic birth and a child that couldn't survive.
Now, despite that message, the defendant's father testified that the family knew nothing of the pregnancy. He asked not to be shown on the witness stand.
Well, we didn't know she was pregnant, and we had struggled with the whole eating disorder since she was 12, 13 years old, where she wasn't telling us what was going on.
Do you know why she didn't feel comfortable enough coming to you and saying she was pregnant?
I wish I did.
At the time when you were questioning Skylar, did you know that the doctor had told her that she had 10 weeks before she would deliver?
I didn't know that.
What would you and Kim have done if Skylar had delivered a live baby and come downstairs with a live baby?
We would have taken it into the family.
Would you have been mad?
I think we would have been in shock, and we probably would have been angry, but
if she had told you that she was pregnant immediately on April 26th, as soon as she found out, how do you think Kim and you would have reacted?
Angry, then shocked.
The defense called a doctor who concluded that Skylar Richardson delivered a stillborn baby. This doctor made that conclusion based on Richardson's eating disorder, and he even recalculated her conception date.
We know going into the pregnancy that Skylar has a long history of an eating disorder. Her weight had bounced around quite a bit. She went in, as often the times with this age group, to begin birth control. Dr. Andrew, like we all do, examined her, realized really quickly she was pregnant. It was his belief on April 26th, and it was probably conveyed to Skylar that she was about 32 weeks pregnant. It was too late for her in the state of Ohio to have an abortion. But the 32-week, 32-centimeter fundal height, I had the retrospective ability to know that that was markedly abnormal, because at the 26th week visit, based on the facts we knew, she was not 32 weeks. She was 39 to 39 and a half weeks, which meant that her fundal height at that visit was lagging by 7 centimeters.
And if the baby's white, as Skylar described it in the interrogation, what does that mean?
It means that there has been no oxygen exchange for a period of time from the mother through the placenta, through the umbilical cord to the baby, so that the prior to death, the fetus has essentially used up all the oxygen.
That doctor remained on the stand defending that conclusion for most of the rest of the day. Still ahead on the debrief, we're heading to South Carolina for the case of a man accused of helping his wife make his girlfriend disappear. The wife has been convicted in connection with the case. Will the husband's second trial result in the same fate? Jury selection moving forward in the death penalty trial of a Florida man accused of killing a 9-year-old girl. Felicia Williams disappeared in 2014 and was later found stuffed in a suitcase which had been dumped off a causeway in Old Tampa Bay. Defendant Granville Ritchie is accused of sexually assaulting the girl, beating her, and strangling her to death. His trial is expected to last 2 weeks. And now to opening statements in the trial of Sidney Moorer. He's the South Carolina man charged in connection with the disappearance of a woman named Heather Elvis. Moorer was dating Elvis, and Elvis has been missing since December 2013, almost 6 years ago. Sidney Moorer's wife, Tammy, seen here, was convicted in a separate trial last fall of kidnapping Heather Elvis. Here's how the state opened the husband's trial.
We're going to show you that this man right here, Sidney Moorer, and his wife Tammy Moorer conspired, planned, and executed that plan to kidnap Heather Elvis on December 18th of 2013 during the early morning dark hours. They worked together at the Tilted Kilt, a restaurant in Myrtle Beach. She's a hostess. He's a night maintenance man. They meet and an affair develops. It develops passionately. It's a romantic affair. And I say affair in the truest sense of the word because he's married to his co-defendant, Tammy Moorer. It stops abruptly. And it stops abruptly for one reason. Because that man's wife finds out about her. Heather Elvis goes to the landing, and that is the last anyone hears from her. Her phone dies, and then she's never heard from again, ladies and gentlemen. Coincidentally, you're going to hear testimony, and you're going to see a video of that man's truck coming from his house down Highway 814 and Mill Pond Road to the only destination on Mill Pond Road at the other end, Peachtree Boat Landing. I'd like to tell you I know what they did with her, but I don't. Because she became their custody and control. And she disappeared.
The defense claims this is a purely circumstantial case. They say police only arrested Moorer due to pressure to close things out.
When she goes missing, Sidney voluntarily comes in, gives multiple statements. Didn't have to do that. His wife gives statements. And we'll see that he's pretty much instantly a suspect because of this affair, which again, he never denied, nobody ever denied, everybody knew about it. But the police develop a sort of tunnel vision early on. And so we'll see that by end of December, maybe early January, search warrants have been executed on his home, on his vehicle, the F-150 that we'll hear so much about. Sidney's cell phone data puts him at his house during the time Miss Elvis goes missing. There is none of her DNA in his truck, no blood, none of his DNA in her car, at the landing, anywhere else. There is nobody saying or showing that he was anywhere near Peachtree Landing on the night she went missing. Sidney Moorer did not abduct, kidnap, or harm Heather Elvis, and folks, he doesn't know who did. You're going to see that he had no motive to wish any harm on Miss Elvis, and he didn't have the means to abduct her or make her disappear without leaving any trace of physical evidence whatsoever. Moreover, you're going to see that the decision to charge Sidney and the investigation that led to that decision was rushed, and it was rushed because they were reacting to the noise.
Prosecutors say the defendant's wife discovered the affair and that Heather Elvis was terrified of her. The wife forced Sidney Moorer to stop working as a handyman where the purported victim also worked. Elvis gained weight quickly before she disappeared, raising rumors that she was pregnant.
There was an abrupt end to Sidney working there. I called him one day to see if he could do some repair work for me. And I called, he answered the phone, I asked if he was tied up, and he said, what do you mean by that? And I said, just need, are you available? And then the conversation went into Heather Elvis and how she was a bitch and a slut and spreading rumors about their family.
Let me ask you, how long did that conversation last?
Maybe a minute and a half, maybe, I'm not sure.
Okay, and to your knowledge, did he know about the rumors that she was pregnant?
I mean, yes.
Okay.
Yes, because it was mentioned that she was spreading rumors that she was pregnant and trying to ruin her family.
Heather Elvis called her roommate crying the night she disappeared. The roommate said during Moorer's first trial that Heather told her that Moorer, the defendant, had left his wife and wanted to be with her. Now, that trial ended in a mistrial, as we said, and today, during this retrial, the judge refused to let that friend testify as such.
She was very upset.
Okay. And did you hear anybody in the background?
No, I did not.
And when you say very upset, was she crying?
She was hysterically crying. The last thing I said to her was to not meet Sydney, go to sleep, and we would talk about it in the morning.
And that's the last time you ever talked to her?
Yes, ma'am.
And the time you lived with her, and the time you worked with her, did she ever look afraid of Sydney Moore?
No, ma'am.
Did she, during this time frame, you worked with her every day, you were seeing her every day, living with her, did she ever appear afraid of his wife, Tammy Moore?
Yes, ma'am.
Back now to attorneys Linda Kenny Bodden and Julie Rendelman. So, Julie, the defense is saying, oh, there's no motive here, no motive. What about the pregnancy rumors? What about the video that shows the defendant going and buying a pregnancy test and then calling up Heather Elvis, who's now missing? How is that not motive?
Yeah, I don't think there's any question that there is motive. I think the issue, and I think that's probably the reason that they ended up in a hung jury, I don't really know exactly why, but is because there are questions about, just as he said, there's no DNA, there's no witnesses that link them to being together at the time she disappeared. And that it seems to be that he was home at the time this happened. That's going to be the problem, and I think it's going to be the problem in this case as well.
You know, so in other words, is this defendant going to blame his wife for everything? So my wife went and did it all by herself?
I don't know that he needs to blame his wife. He just has to make it clear that they can't prove the case against him beyond a reasonable doubt.
Or he could do both. Linda Kenny Bodden, what's going on with the hearsay thing with the judge saying, oh, you can't let the defendant's statements to the purported victim into this case? Because usually a defendant's statements can come in over a hearsay rule.
Well, the problem is that it's triple hearsay. It's not just to the person, it's somebody then relating another statement. So it's a triple hearsay.
Well, there's a rule for hearsay within hearsay, and it basically says it
and
applies to all the other rules.
You know what it comes down to? The judge thinks that could be reversible if that's all this conviction will be based on, and he wants to protect the conviction.
I mean, but isn't there more that this could be based on other than just that?
Oh, yeah, there's a lot more. I think you do have all the motivation, and indeed, you know, at Tammy's trial, his wife's trial, they said, well, the pregnancy kit didn't count because Tammy ended up being pregnant. She bought her for herself. But no, it does count here. This woman thought she was pregnant. The last call was to his cell phone. To me, that's pretty good evidence.
A lot to talk about. We're just in day one of this case. Thanks to Julie. Thanks to Linda. Appreciate the insight here on the debrief. And thanks to those of you watching along with us. We appreciate it. Our live trial coverage resumes tomorrow at 9 o'clock Eastern on the Law and Crime Network in all of these cases. We'll see you then.